please put your hands together for the Commissioner, Dr. Tim Soutphommasane. I said it twice.
Well, thanks, Amanda, for that welcome. It's wonderful to be with you tonight, and may I begin by acknowledging His Excellency Governor Hugh Van Ley, Mrs. Lan Ley, and particular thanks for your generous words, Governor, to the parliamentarians, mayors, Mr. David Lynn, President of ARA, Kirsten Bickenhoff, CEO of ARA, Jacinta Thompson of the Hawke Centre, ARA board members, staff, volunteers, members, distinguished guests. I also want to acknowledge the Kaurna people and pay my respects to them as the traditional owners of the land on which we meet. It's a real honour for me to be with you tonight to deliver this oration, and what an auspicious occasion it is, the 40th anniversary of ARA. And I would like to commend the work of ARA over 4 decades in helping refugees settle in Australia. And I say this as the son of refugees myself. My parents weren't refugees who came to Australia in the first instance. They were refugees who went to France. But hearing stories about their time settling in France, I know that they are eternally grateful to all those who offered them a warm welcome. It may sound a little trite, but even the smallest gestures of generosity can be remembered for a very long time by those who arrive as outsiders in search of a new home. ARA's contribution is very much a nation-building one, and you can all be proud of the significant difference that you have made to the life of our nation. Last week I was in Tokyo, where I spoke at a conference on Australian studies. I had remarked on what I believed to be the exemplary story of our post-Second World War history as a nation of immigration and cultural diversity. Later, one Japanese scholar questioned me about the success of our multiculturalism. What you see as success from inside Australia, she said, is slightly different from the view of Australia from the outside. I asked her why this was so, and the scholar said that it was difficult to reconcile Australia's treatment of asylum seekers, particularly those who arrive by boat, with the notion of a welcoming Australian multiculturalism. Now, this exchange sums up for me one of the tensions in our multicultural experience. If we have, indeed, been so inclusive of those who arrive on our shores, why is it that there appears to be such deep political and public concern about certain outsiders? And might there be potential for issues concerning immigration to contaminate our celebrated social cohesion and cultural harmony? These are some of the questions I will address tonight, and I'd like to do so by exploring the idea of sanctuary, a notion often invoked in our depictions of an Australian way of life. It's an idea, however, that captures much of the ambivalence that exists today towards asylum seekers. It's an idea that throws light, perhaps, on both the inclusive and exclusive sides of Australian nationhood. The idea of sanctuary is, of course, central to how we should treat refugees. For those refugees who make their way here, or try to, the country's promise is as a place of shelter, whether that's from war, strife, violence, or discrimination. The idea of sanctuary has its roots in the Old Testament. Within the Old Testament, there are references to cities of asylum, where anyone who had perpetrated an unintentional killing of another would be protected from the avenger of blood. Recognised by the Roman emperors Theodosius and Justinian, the concept enjoyed the sanction of the Christian Church from the 5th century, and the church as sanctuary was protected under English law until the Reformation. Elsewhere in Europe, the church was treated as a sanctuary until well into the 18th century. The contemporary understanding many Australians have of our country as a sanctuary is far from moralised or ecclesiastical. These days, rather, an Australian sanctuary connotes something of a lifestyle nation, something epitomised by surf and sunshine, backyards and barbecues, open spaces and easy living. It's only natural, then, that the word sanctuary applies frequently in the names of new residential developments, such as Sanctuary Cove, Sanctuary Lakes, Sanctuary Grove, actual suburbs, by the way. There is contemporary suburban yearning here, if not for master-planned communities, then for a kind of cultural haven beyond the reach of all disturbance, though, of course, not one that's too far away from a shopping mall. I'll return to these cultural aspects of sanctuary a bit later, but for now, let me say a little about Australia's record in providing sanctuary. We should begin with the fact that Australia is a signatory to the United Nations Refugee Convention. As a country, Australia has a legal obligation not to return someone to their country of origin if they are in well-founded fear of persecution. It was very much the case that Australia was a sanctuary for those escaping from strife in the 20th century. We took in hundreds of thousands of displaced persons from Europe at the end of the Second World War. In the late 1970s, of course, Australia took in tens of thousands of refugees who had fled Southeast Asia, a number bolstered by the many more thousands who would arrive from the region through family reunion schemes. There were clear rationales to the acceptance of these refugees, quite clear rationales in addition to humanitarian obligation. In the years following the Second World War, it was the task of national reconstruction. And in the years following the Vietnam War, there was a particular responsibility to accept refugees in light of Australia's military support for the South Vietnamese government. In both cases, however, the offering of sanctuary meant significant change to Australian society. When the Displaced Persons Resettlement Scheme was introduced in 1947, it marked a significant cultural shift. For until then, since the advent of the White Australia ideal, immigration policies had always prioritised taking in people of Anglo-Celtic heritage. And when refugees from Southeast Asia arrived in the 1970s, it was, you might say, the first test of whether Australia was truly prepared for the practical implications of abandoning White Australia. The arrival of refugees has made a significant contribution to our society, to our cultural, economic and civic life. In just about every field of endeavour, those who have arrived here as refugees have made their mark. And we need look no further than your Governor, Mr. Hugh Van Ley, an inspiration to all those who have heard his story and to all those fortunate enough to come to know him. Or consider some of our achievers and personalities in sport, or the arts, or in entertainment. Fawad Ahmed, Majak Daw, An Do, Luke Nguyen, Nam Lee, Les Murray, to name but a few. I was especially struck earlier this month about the contribution of refugees while I was reading the BRW Rich List. I don't know how many of you read the Rich List when it comes out, but these days it comes out in a magazine fold-out in the Australian Financial Review. I got this copy and I wanted to take a look at the list, but these days the list is in the middle of the magazine and you have to fight your way through a lot of pages of advertisements for Rolex watches and Louis Vuitton handbags and the like. But once I found that list, there it was. Well, there they were. Names like Pratt, Triggerboff, Loewy, Gandel. People whose families were refugees, or if not refugees, then migrants who had left their homelands, or whose parents had left their homelands. Of course, we shouldn't judge the contribution of refugees to our society merely on the basis of some prominent examples. We should look at the overall picture. And if we speak in economic terms, the story is a very positive one. The late South Australian demographer Graham Hugo, in his comprehensive 2011 study of first and second generation humanitarian entrants, found the following. Over time, unemployment and participation rates for refugees converge toward those of the Australian born. Those who arrive as refugees also have high occupational mobility over time. So, in other words, the results are very good. Granted, it's not all positive. For instance, refugees face substantial obstacles to employment in their early years of settlement, an issue I know that ARA deals with. But the ultimate findings of Hugo's study were very clear. Refugees are successful members of our society. I believe it's worth reflecting on the contribution that refugees have made in particular communities as we assess the question of impact, namely those in regional and rural parts of the country. Earlier this year, AIMS, a settlement services provider, released a report on the experience of Nil, a small town in northwest Victoria. Now, let me tell you a little about the experience of Nil. Between 2010 and 2014, some 160 Karen refugees from Myanmar or Burma have settled in the town. The Karen settlement there has more than doubled the number of people in Nil who were born overseas. So the impact has been very significant, you might say, in terms of the cultural and ethnic face of that town. But those who resettled found employment in the expanding Loverduck company that's based there. Attendance at the town school had for some time been in decline before the refugees arrived, but now that trend has been reversed. The study done by AIMS was done in conjunction with Deloitte Economics, who did some modelling on this, and they found that the total impact for the local economy is in the vicinity of $41 million over the 5 years that I mentioned. Unemployment today in Nil is almost nil. It's 2.8%. And perhaps most importantly, the new arrivals have been welcomed as part of the local community there. In short, the result of resettling Karen refugees in Nil has been a triumph. It has had a regenerative effect on an area that had been in decline. Let me return now to the cultural aspects of sanctuary. Such aspects aren't always compatible with the moral aspects of sanctuary. In the case of refugees, when we talk about sanctuary, we're talking about the provision of sanctuary to an outsider. But if we understand sanctuary as a lifestyle, then sanctuary is an object that is to be protected from outsiders, or at least that's how it's often understood. We can illustrate this tension in numerous ways. Perhaps most notably, it is there in how public frustrations about infrastructure and urban congestion, not that you may have this in the same magnitude as we do in Sydney or in Melbourne, but in how these frustrations are linked with concerns with boat people who arrive in Australian waters. Thus, there will be occasions when refugees are blamed for increasing traffic in our cities or for placing greater burdens on schools and hospitals. And this points to a broader point. The desire for a certain cultural security isn't necessarily sympathetic to cultural diversity and immigration. Population growth is perceived by many as a threat to our national lifestyle, to a traditional Australian way of life. It's seen as a destroyer of a comfortable existence in the suburbs, one that we picture in terms of large, green backyards where children can play cricket, climb trees, or, in the words of Dick Smith, roam free range. The implication, though, in all of this is clear. In providing sanctuary to outsiders, we may end up undermining the cultural sanctuary we currently enjoy. Scholars have provided some interesting accounts on all of this. For example, cultural theorist Suvendrini Pereira of Curtin University argues that there has been a shift in our population debates from a language of sovereignty and security to one of sustainability. In her view, the opening decade of the millennium, dominated by the Tampa incident, the September 11 attacks, and the Pacific solution, led population debates to be framed as ones about border security or protection. But with the marriage of concerns about quality of life, sustainability has been mobilised, she argues, into defensive and insular nationalist discourses. Here's what she says. Questions of population are always about race, ethnicity, and the reproduction of the nation. It's an interesting account. I do think there are limits, though, to that explanation, because it's just another way of saying that all debates concerning population or refugees must involve racist dog whistling in one form or another. But I think it's odd and perhaps also dangerous to label anything and everything as racist. This isn't to deny that race plays no role at all. Reflecting on hardened public attitudes towards asylum seekers during the past decade or so, the political historian Robert Mann has put it in concrete terms. Were the majority of asylum seekers who arrive in boats to be white Zimbabwean farmers and their families fleeing from the regime of Robert Mugabe, rather than Afghan Hazaras or Iraqis or Sri Lankans, according to Mann, it would be improbable, or so it seems to me, that public opinion would have tolerated their detention behind razor wire or their transportation to the hellhole in Nauru. End of quote. Having said that, not everyone who supports a hardline approach to boat arrivals is motivated by xenophobia or a fear of third world-looking people. For many, even the harshest or most draconian means of stopping the boats is justified by the risk of death or injury that boat-borne asylum seekers face. On this view, asylum seekers are the victims of exploitation by criminal people smugglers, and we must do whatever we can to stop the trade. Some Australians also believe that a softer stance towards boat arrivals may offend the idea of a fair go, by having the possible effect of disadvantaging refugees who are already awaiting resettlement in camps overseas. I mention all of these reasons that are put forward in the debate just to highlight how I believe that it's wrong to suggest that race is the only factor that motivates an exclusive understanding of sanctuary today. Now, one of the frequent exercises of analysis on all of this is that of identifying exactly when hardened attitudes towards asylum seekers emerged. It's an interesting exercise, I believe. After all, aren't we the country that took in refugees after the Second World War in such dramatic numbers? Aren't we the country that in the late 1970s took in tens of thousands of refugees fleeing the turmoil in Indochina? And haven't we seen in the past 4 decades the emergence of a country that is relaxed and comfortable about its multicultural character? If all this is true, why then do we have such hardline attitudes among so many Australians? In retrospect, there were several reasons why those waves of refugee resettlement were successfully conducted. In the case of post-war displaced persons from Europe, their acceptance was central to the exercise popularly known as populate or perish. The story of refugees from Southeast Asia is slightly different. As already mentioned, given that Australians had fought alongside the forces of South Vietnam, there was a direct moral obligation to take in refugees who were displaced by the war, a point that seemed to have been appreciated by the Australian public at the time. Any public concern about accepting Southeast Asian refugees may also have been allayed by the fact that the Fraser government embarked on an offshore program of resettlement. Of those who were resettled in Australia, about 56,000 refugees came via processing conducted in camps across Southeast Asia. When you combine that total with those who arrived subsequently through family reunion, the total sits at about 190,000. But in short, as the political historian Paul Kelly has written, the key to this Australian triumph was converting the intake from onshore to offshore. There was perhaps one other reason why Indo-Chinese refugees were resettled without much rancour, and it explains much of the success of Australia's multicultural reality over the past 3 or so decades. The reason is quite simply this: both major political parties agreed not to play politics with race. From the time a planned migration program was introduced in Australia following the Second World War, bipartisanship of a certain kind could be taken for granted. Neither side of politics would seek to make political mileage from immigration issues. The stakes were simply regarded as too high. Which brings me now to the exact point, or the inflection point, when Australian attitudes towards refugees hardened. I would say that the bipartisan political consensus broke down in the 1990s. Many would say that this coincided with the impact of Pauline Hanson's One Nation. But there were signs of this even before Hanson's emergence. If we're talking about asylum, a persistently negative attitude towards asylum seekers was given clear expression, namely through the introduction of mandatory detention in 1992 as a deterrent to boat arrivals. Still, with Hansonism, there would be a palpable effect on public attitudes and public policy. For example, Hanson herself proposed that those proven to be refugees should be afforded temporary sanctuary from persecution in their homelands, a proposal that would be given effect through the advent of temporary protection visas. Those in favour of a more sympathetic approach to asylum seekers also found themselves increasingly maligned for being complicit in a so-called multicultural industry. Hansonism and its subsequent impact made it acceptable to politicise asylum seekers as part of a much broader debate about multiculturalism political correctness, and national identity. In my view, these developments in our political culture have made it harder to discipline or limit our exclusionary tendencies. Yet, as it always has been, perhaps more so now, political leadership is vital. Political leaders set the tone for our society. Their role on asylum and immigration is paramount. And where leadership on this is lacking, there may be the very real risk that any hostility directed at outsiders may also assume the form of hostility towards our fellow citizens. It may not be possible for us to quarantine certain social sentiments. After all, not everyone will draw a distinction between an asylum seeker, a refugee, an international student, a migrant on a skilled worker visa, a first-generation Australian, or a second or third-generation Australian. I've even been told that it has sometimes been the case that Aboriginal Australians have been told to go back to where they came from. Clearly, there is a danger that anti-refugee sentiments may spill over into general cultural antagonism. On such matters, political leadership, while necessary, is not sufficient. The law must also play a role. To be sure, we shouldn't place all of our faith in legislation. Martin Luther King, for example, once said, "It may be true that morality cannot be legislated, but behaviour can be regulated. The law may not change the heart, but it can restrain the heartless." Our laws can indeed set a standard for our conduct in society. Put very simply, they express our common values. They serve to educate our sentiments. This year is one where quite a number of people are marking their 40th anniversary. It's a year of many anniversaries, and that's the case as well of the Racial Discrimination Act. Enacted by the Whitlam government, it was Australia's first federal human rights and anti-discrimination legislation. To explain the impact of the legislation, consider this. Prior to 1975, if someone experienced racial discrimination, there was very little that they could do through the law. The law wasn't on their side. If someone had been turned away from a shop because of the colour of their skin, or turned away from a hotel because of their ethnicity, someone had no avenue for making a complaint. There was simply nothing the law could do. It was only with the Racial Discrimination Act that someone in such a situation would enjoy the assurance that the law was on their side. And over 40 years of operation, the law has had a significant impact on human rights and public law in this country. For one thing, it set a precedent. Since 1975 and the RDA, the Parliament has legislated as well to prohibit discrimination on the grounds of sex, disability, and age. The Racial Discrimination Act has also played a role in facilitating the development of Aboriginal native title. It's also been a practical instrument. Since 1975, there have been more than 6,000 complaints that have been successfully conciliated under the Racial Discrimination Act. The fact that it involves conciliation here is important because the law does not serve to punish people so much as it does to educate people about discrimination. There's perhaps been one particular area where the legislation has been important in shaping our sentiments and our public life. Since 1995, the Act, through Section 18C, has made it unlawful to offend, insult, humiliate or intimidate others because of their race. The prohibition on racial vilification was introduced following the recommendations of a number of major inquiries, including the Royal Commission into Aboriginal Deaths in Custody and the National Inquiry into Racist Violence. It reflected a concern in the 1990s that racist violence would emerge or be exacerbated if there weren't laws to nip it in the bud. Section 18C has been talked a lot in recent times, but not quite as much attention has been devoted to Section 18C, which accompanies 18D, which accompanies 18C. 18D protects freedom of speech in a number of categories. So, if you do anything that's artistic work, that's academic or scientific inquiry, that's fair comment or fair reporting on a matter of public interest, then your conduct will be exempt from 18C, provided that you've done it reasonably and in good faith. As all of you will know, last year the federal government proposed a repeal of Section 18C, though following widespread public opposition, it decided not to proceed with those changes. It was welcome that the government heeded public concerns about a repeal of Section 18C, because the very real danger of repealing it was that it may have emboldened people to vent their prejudice and hatred in public. It would have encouraged people to believe that they could give voice to bigotry with absolute impunity. It was encouraging, though, that many Australians were on the side of racial tolerance rather than bigotry. In April last year, a Fairfax poll showed that 88% of people believed it should remain unlawful to offend, insult, or humiliate people on the grounds of their race. It's perhaps no accident that a similar percentage of Australians have consistently expressed support for the proposition that multiculturalism is good for our country. That's in the Scanlon Foundation's surveys into social cohesion, where in the last 2 years, 85 and 86% of Australians have said that they believe multiculturalism is good for the country. A very similar number to that which supported the current provisions of the Racial Discrimination Act. My point here is that racial tolerance and multiculturalism go hand in hand. That the protections of the Racial Discrimination Act were vulnerable, however, points to certain limits in our laws. It highlights that an Act of Parliament can be overridden by another Act of Parliament. Legal protections of rights may be vulnerable to parliamentary will. By way of illustration, if I may, just indulge me while I depart from the Racial Discrimination Act briefly. Currently, as you will know, there has been a debate about proposed changes to our citizenship laws. No bill has yet been presented to Parliament, but we do know that the federal government is considering laws which would empower the Minister for Immigration to revoke citizenship from dual citizens and possibly also other citizens. Now, I share the concerns that have been expressed by many parliamentarians, legal experts, as well as my colleagues, Professor Gillian Triggs and Tim Wilson at the Human Rights Commission. It's important, naturally, that governments take all reasonable and necessary steps to combat terrorism and threats to national security. But citizenship is the common bond that Australians share. if there are to be changes to our citizenship laws, we need to have careful deliberation. And we must adhere to a number of principles. For one thing, Australia should not be depriving anyone of nationality completely. No one should be left stateless by any laws. And if citizenship is to be revoked, the magnitude of the act should be reflected in the procedure used. Namely, the exercise of such power should be based on a conviction rather than a suspicion, and it would best be done through a determination not of a minister, but a determination by a court of law. Finally, we should consider the impact of any change to citizenship laws on our social cohesion. One of the risks is that a change could create an impression that there are different classes of citizenship in our country. What we don't want to do is to make people who naturalise as citizens or who are second-generation Australians feel that their standing as equals is less secure than others. But let me return now to the Racial Discrimination Act and the limits of legal protections against discrimination. For all that it does to act as a bulwark against racism, and for all that it does to remind people that they can be assured equality and dignity, the Racial Discrimination Act shouldn't stand on its own. Recent history shows us that the Act is vulnerable to being suspended through another Act of Parliament. That is to say, there should be a constitutional statement about racism to support our existing legislation. If we are to recognise Aboriginal and Torres Strait Islander people in the Constitution, as I believe we should, then this should be accompanied by the removal of clauses that currently permit racial discrimination. And there are still 2 clauses in our Constitution that allow this. Section 25 permits states to disqualify people from being eligible to vote in elections because of their race. Section 51, subsection 26, empowers the Commonwealth to make laws with respect to any race of people, regardless of whether it's for their benefit or their detriment. In my view, there should be another thing. We should also guarantee racial non-discrimination in our Constitution. The concept of sanctuary raises 2 sets of questions, and I hope that they've become clear so far in my remarks. One is about human rights. The other set of questions is about membership. And I'd now like to briefly consider whether we can reconcile these 2 concerns. In terms of human rights, the legal and moral obligations that Australia owes to asylum seekers are clear, crystal clear. We are, as a country, as one of the signatories to the Refugee Convention, committed to ensuring that those with a well-founded fear of being persecuted for reasons of race, religion, nationality, or membership of a particular social group or political opinion are protected. The Convention binds its signatories not to impose penalties on those who seek asylum, including on account of their mode of entry or lack of authorisation. Article 33 of the Convention also imposes a duty of non-refoulement, which states that a refugee shall not be repatriated to their homeland if their lives or freedoms are threatened. In practice, though, the manner in which signatories give effect to such duties varies. The refugee scholar Matthew Gibney puts it in the following way: liberal democratic states publicly avow the principle of asylum, but use fair means and foul to prevent as many asylum seekers as possible from arriving on their territory where they could claim its protections. One reason, perhaps, why the machinery for all this is perhaps that the machinery supporting the international protection of refugees was the product of the Second World War. The drafters of the Refugee Convention wouldn't have anticipated the scale of the global refugee population that exists today. The UNHCR estimates that there are well in excess of 40 million people who are considered refugees. The framers of the convention also would not have anticipated the globalisation of asylum, the relative ease with which people these days can flee strife and persecution in Asia, the Middle East and Africa, and reach liberal democracies in the West. If I may very briefly, I want to say a little about the case of Germany to highlight some of the tensions at play here. Following the Second World War, West Germany adopted as its constitution the Basic Law, which enshrined the principle that, I quote, "persons persecuted on political grounds shall enjoy the right to asylum." It was a deliberately wide interpretation of a right to asylum, which reflected West Germany's conviction that there would never again be mistreatment of refugees on German soil. During the 1950s and 60s, the number of people seeking to exercise this right on German territory was small, about 5,000 a year. But things changed in 1980 as a result of civil wars in Turkey, Sri Lanka, Lebanon, and elsewhere. With the fall of the Berlin Wall in 1989, along with the crisis in Yugoslavia, we also saw influxes of asylum seekers hitting Germany. Increasingly, the asylum clause in Germany's constitution served to attract asylum claims from those with weak claims for asylum, but who nonetheless had every reason to make an application to start a new life in the West. So by 1992, the number of annual applications for asylum in Germany had risen to 438,000. The philosopher Andy Lamy has written a very good book on these issues. As he says, eventually the Basic Law's asylum clause had the most powerful effect of being negative by creating an incentive for economic migrants to file unfounded asylum claims. In 1993, the German Parliament voted to reform Germany's asylum law. This generous legal protection of asylum seekers was consigned to the dustbin of history. I use the German example to illustrate the following point. If there is a duty owed by political states to refugees, and there is, it clearly cannot be an unqualified one. For all of the universalism that attaches to the language of human rights, any protection afforded to asylum seekers remains shaped by political realities. What is a universal right in theory may be a somewhat limited one in practice. This is a long way for me to come back to the questions of membership, which I flagged earlier. I think there clearly is a philosophical and political tension between human rights and national sovereignty. In a globalising world, communities are confronted with a choice between a universalism that makes no distinction between members and strangers, and a particularism which takes national self-determination seriously. For the universalists, we are simply citizens of the world. Our citizenship shouldn't be defined by our membership of national communities. You can be Afghan or Australian, Sri Lankan or Swedish, but you are all entitled to equal, non-negotiable rights of liberty and security. And these rights should trump any right that nations have to territorial integrity. If we apply this to asylum seekers, the universalist case places a burden on developed countries to relax their claims to territorial rights. But if we apply such thinking, it's unclear to me how such universalism can work in practice. Because the argument emphasises the fundamental moral equality of human beings sits in tension with an account which takes membership of a particular state or community seriously. And national membership still matters for the vast majority of people. If we're talking about how to allocate resources or how we share goods, such questions presupposes a notion of membership. What we do with membership, whom we admit, and how to our community shapes all of our other decisions. And a democratic value of political self-determination would seem to mean that a community must have the right to exercise sovereignty over its borders. Any right of protection that refugees are entitled to enjoy requires, in the current context, cooperating nation states to give that protection effect. I say all this because we shouldn't make the mistake of thinking that being sympathetic to diversity or to refugees means that we should support the radical idea of open borders. In fact, a multicultural approach exists very firmly within a framework of national self-determination. It presumes a contract between citizens and their government in which immigration is in line with that community's national aspirations. Indeed, in historical terms, Australian public acceptance of mass immigration has been contingent on nation-building ambition. For example, during the past decade or so, Australia has sustained high numbers of immigrants, partly because there has been a points system of admission geared towards immigrants meeting the needs of our economy. Some have even argued that a strong border protection regime may be a prerequisite for a strong overall migration intake, though I think this is very open to debate. At its very essence, however, the Australian model of multiculturalism and immigration has been based on a value of citizenship. Those who come here are expected in time to become Australian citizens. They are free to enjoy all the rights that come with citizenship, but they are also expected to fulfil their obligations as citizens, to have loyalty to Australia, to be committed to our democracy, to uphold our laws, to respect the rule of law. Underpinning all this is an assumption that there must be trust and solidarity among citizens. So let us imagine then, what would be the result if Australia were to adopt a position of opening our borders? Would it still be possible to maintain such trust and solidarity if we had open borders? I think there are good reasons to believe that there's a certain point beyond which trust and solidarity in a multicultural society would not be possible. And here, I think it's worth being reminded of what Hannah Arendt referred to as the right to have rights. According to Arendt, this is what citizenship meant: the right to have rights. And there's a clear and consequential distinction between citizens and foreigners. Citizens enjoy certain rights and protections that foreigners simply do not. What makes the refugee vulnerable is precisely that they, for whatever reason, can no longer count on their government defending such rights as they possess. And the most powerful claim they make is that of humanity, what Arendt called the abstract nakedness of being human. But here's the question: how do we enforce such claims if communities may be resolved to exclude the people who make such claims? Let me conclude. Grappling with questions about human rights and membership is another way of looking at that initial contrast that I drew between the moral and cultural dimensions of sanctuary, the two modes in which we respond to the demands of protecting outsiders. Many, I feel, mistakenly assume that a particularistic approach to immigration leaves no room for considerations of justice for outsiders. But self-determination needn't mean rule for the mob. It needn't mean populism. Because to endorse self-determination isn't to endorse the idea that a political community should merely follow the lead of public opinion or pander to the lowest common denominator. It is only to say that we recognise the value that people in a community place on having a model of membership that they regard as legitimate. At the very minimum, a liberal nation-state has a responsibility to uphold basic human rights. It must be willing to accept refugees whose basic rights have been violated or are at risk of being so. And states should admit or accept as many refugees as they can without undermining the provision of collective or public goods among their existing members. In the case of Australia, the notion of national sovereignty or cultural sanctuary cannot justly be invoked to close off certain obligations which we have and which we have willingly entered into as a country. By willingly choosing to sign the Refugee Convention, Australia proudly said yes to refugees and said yes to asylum seekers fleeing persecution. In any case, if a debate about asylum seekers is to be guided by notions of national sovereignty and by notions of national values, well, an Australian community would have to take seriously an ethos of a fair go. Such an ethos would mean little if we are incapable of extending it to those most vulnerable. Thank you very much. Yes, sir.